Start. The Judicial Committee of Privy Council entertained and allowed a petition to have its order for dismissing the appeal and affirming the judgment of the court below recalled, and for leave also to prosecute the original petition of appeal. Stop. This was in a civil matter, but the observations of their lordships have a significant bearing on the question of inherent powers of the High Court, practically the last court of appeal in criminal matters. Stop. Para. It is unquestionably the strict rule and ought to be distinctly understood as such that no cause in this court can be reheard, and that an order once made, that is a report submitted to His Majesty and adopted by being made an order in council, is final and cannot be altered. Stop. The same is the case of the judgments of the House of Lords, that is, of the Court of Parliament or of the King in Parliament, as it is sometimes expressed, the only supreme tribunal in this country. Stop. Whatever, therefore, has been really determined in these courts must stand, there being no power of rehearing for the purpose of changing the judgment pronounced. Nevertheless, if by misprision in embodying the judgments errors have been introduced, these courts possess by common law the same power which the courts of record and statute have of rectifying the mistakes which have crept in. Stop. Para. The House of Lords exercises a similar power of rectifying mistakes made in drawing up its on judgments, and this court must possess the same authority. Stop. The Lords have, however, gone a step further and have corrected mistakes introduced through inadvertence in the details of judgment, or have supplied manifest defects in order to enable the decrees to be enforced, or have added explanatory matter, or have reconciled inconsistencies. Stop. But with the exception of one case in 1669 of doubtful authority here, and another in Parliament of still less weight in 1642, no instance, it is believed, can be produced of a rehearing upon the whole cause and an entire alteration of the judgment once pronounced. Stop. Their lordships have carried their discretionary power of alteration no further than to rectify errors of a subordinate kind, and in very peculiar circumstances to indulge parties by keeping partial questions open which the decree had concluded without there having been any distinct intention of that kind on the part of the House. Stop. It is impossible to doubt that the indulgence extended in such cases is mainly owing to the natural desire prevailing to prevent irremediable injustice being done by a court of the last resort, where by some accident, without any blame, the party has not been heard, and an order has been inadvertently made as if the party had been heard. Stop. Para. There is another case in the books of the council. Stop. Office, which has been referred to as an instance of the council permitting a rehearing, but that was before the order made on the first hearing had been confirmed by the king and was also in a criminal matter from Minorca, being a petition for the remission of the sentence passed upon conviction of perjury. Stop. The council, having upon the first hearing remitted the whole sentence, afterwards reheard the case at the instance of the governor when a partial remission was substituted. Stop. Para. It is clear from this case that there remains a certain power referred to as the discretionary power in the last court of appeal, at least for rehearing of a decided matter in extraordinary circumstances justifying it, and that such a power must naturally be used very sparingly. Stop.